to court. That's a bezrait of a desire. And Rahman al we see, I don't know what it is in Florida, but let's talk about other areas. We see that people go to court either inadvertently, they don't know better, or they do know better, but the Yetzirah just takes them, and they have all sorts of meira hetes why they have to go to court, why they're allowed to go to court. Most of the time, nothing is real, but nevertheless, they're drawn to go to court. There's that attraction. Court takes longer. We have lawyers here, so they can attest to that. It takes longer to adjudicate. It's more costly. It's most probably not even, you don't even feel that you're getting an accurate psak there, because, I don't know, again, I can't speak for the judges in Florida, but I could talk about other judges. They have a whole different way of adjudicating cases. Let's just say it nicely like that. So the kids are, but nevertheless, somehow there's an attraction to go to court. Where does that attraction come from? It comes from the Yetzirah of Avodah Zarah. And it's a Bazrayu of Avodah Zarah. Some even say, a Lashon, that it could be a union of Yarag Valyava. Because since we know that the cardinal Averis, the three cardinal Averis, one being Avodah Zarah, has the principle called Yarag Valyava. A person has to give up his life before committing that Avera. Could be that going to court, according to some, might even go into that. That's Yarag Valyava. Let's break this apart. Let's break this down. The Issa of Lifnei V'lo Lifnei Arkaos actually has two parts to it. One is the medium, the judges, and the other is the body of law. And I'll explain. There's an Issa to go to court because you're adjudicating, you're submitting your claims in front of a secular judge. It's a judge. The problem is the judge, regardless of the body of law that he applies. Even if, in this particular area, the halacha and lahavdil courts are the same, the one and the same, and the psak, the decision that you're going to get from the judge, is exactly the same as halacha, still there's an issa of going to court, because you're adjudicating, you're submitting your claims in front of a secular judge. So the issa is mitzad the judge itself. And then there's another problem. The problem is mitzad the body of law. Even if there would be Jews who are the judges, but they would apply a secular body of law to adjudicate your claim, that would also be an issa of lifnei Arkaos. Because the pasuk says, "Ela mishpatim eshetosim lifneim." It has to be these mishpatim in front of lifneim, in front of Yidden. If you take these mishpatim and go to goyim, but even though they have the same mishpatim, or for ket, you go in front of Yidden, but you don't use El HaMishpatim, you use different set of laws, that's also going to be an issa of Arkaos. Most notably, it's today, in the Beit HaMishpat, in Eretz Yisrael, we have Jewish judges, but the body of law that they're applying is foreign, is alien to Torah. It's not Torah, it's secular law. And secular law that they're doing is also an issa of Elam Mishpatim Mishatasim Lifneim. And all the places in Eretz Yisrael, Chazanish, and many hold that an issa Arkaos to go to the Beit HaMishpat in Eretz Yisrael, because even though Jewish judges, but we have a problem because the body of law is secular. So either one, either the law, the body of the law is the problem, or the judges are a problem. On an aside, I want to share with you a story. There was a certain judge in New York, before he decided to become a judge, he was not sure if this is the right thing to do for a Jew to become a secular judge. So he went to the Baba of Rebbe Zatzal to ask an Eitzah, bracha, shouldn't he go into this endeavor of becoming a judge? And he went to the Rebbe, and the Rebbe told him, it's fine, you could be a judge, but he told him on one condition. Condition is that when you see two Yidden coming in front of you fighting, do me a favor, send them to Beis Din. If you see both sides coming, that was the Baba Rebbe gave him. Fine. Let's fast forward about 20 years later. I don't know if the Olam here in Florida, I'm sure it's into the learning, not following politics, but there was a big Bava Machloikis that happened in New York, 45, 48, whatever, and they decided, for whatever reason is, they had to, on a certain issue, go to court. And the Kosh Baruch Hu was Mesaviv Kol HaSibos and made them go in front of this very judge. When they got to court and he sees what's going on in front of him, he called the counsel to the bench and he told him, he says, I want to share with you a story. And he told him this story. He said the Rebbe had Ruach HaKodesh. Get out of here and get to Beis Din. That's what happened. Fine. So, the body of law is a problem, and the forum is a problem. Judges are a problem.
Is this only when it is two litigants against each other, or is this even like by building codes and all the other things?
No, it's not going to be like that. Mitzvah we'll discuss, but if you're asking now, I don't mind saying it now. No, the is only when you adjudicate. You could go to driver's license and you can get codes and permits and all that. That's fine as long as there's no adjudication with someone else. When you start dealing with a fight between you, a dispute between you and somebody else, that's when you have a problem. Sometimes it could be negaya to building, if let's say you have to get variances and you have to go to the township, I don't know what's here in Florida, but between you and your neighbor, so that could be more challenging. At that point, then you're going to have to ask a shayla how to do it, how you're allowed to go. But let's put that aside. But anything that you're going just put as a process to go there, it's not a problem. But if you're going there to adjudicate, you want a decision, if you need a decision, that you can't go there.
Does it apply to Tain or Nitten as a corporation?
Yes. It wouldn't make a difference if they are Jewish members of that corporation, if they're Jewish partners or Jewish members of the LLC. So then, yes, and then they are Jewish, and then they have to go to a Beis Din. So, now, I want to take to the next step. Even though Rashi says a lashon miyakesh shem elilim, which might give an impression that we're only talking about where the secular law is religious based. There are courts, certain courts that are religious based. But that's not true. Even if it's nothing to do with religion, even if it's a totally secular law, let's say in America, it's a secular law not based on religion, still there's an issa of Arkaos. And that's already, not now, it's already from the times of Tashbats. There were countries that had secular law that were not religious based. And he said in a number of places, he said, Avada, there's still an issa of Arkaos. There's a Yochanan Bais, a Chuvas Yochanan Bais, a Kadmon who says it, Ramosha says it. It's a pashut that it applies even today, even if it's just a secular body of law. Not only is it an issa to go there for a decision, but even to carry out, even to mete out the justice, even to carry out a psak din. Let's say you have a psak from Beis Din, and now you want to go to court to enforce the psak Beis Din, confirmation of award, and then you want to enforce it, to use them to be your shoitrim. The Gemara and Gittin darshans that even that's a problem. You can't use them to be a shoitrim either. Nothing, not only that, you can't even use them to compel arbitration. Ma'asim b'chol yom, we could write in a contract that we're going to a dispute resolution clause that we go to arbitration in front of a Beis Din, and if for whatever reason is one party is not cooperating, let's just say nicely, and therefore you have to get the court's involvement to compel arbitration. That is, that you show them that both sides contracted to go to a Beis Din, and you're asking them to step in and force them to come to Beis Din, which has been done time and time again, even to compel arbitration by the court. So what are they doing? All they're doing is sending you to Beis Din. Even that, the Ramah says that it's also a royal Moscow. He deserves to get patch. He deserves to get malchus. Even that is a problem. You can't use them. You can't involve them in the process of Beis Din. So what can you do? So we're going to learn in Mitzvah. There are ways out. What do you do when you're stuck? If the person's not willing to go to a Beis Din, what do you do then? And we're going to discuss, but we'll get there. So basically, the issa is the judges and the body of law, and even to implement the law is also a problem.
Does that apply to standard arbitration in front of a third-party arbitrator?
Okay, so that's a very difficult question, and that's really not for today. But if you're asking it, I'll mention it just briefly. There are different types of arbitration. There are arbitration where, let's say, the American Arbitration Association, a difference where they will get lawyers or judges, or they will get at least people familiar with secular law. So if the kavan is that you want to apply a secular law, so then you're going to still have the same issa. But sometimes what you could do is, and this is really not Simcha Vav, it's really Simcha Bais, and that is where you want to go to somebody because you value his opinion. Let's say he's big in business and he knows the ins and outs. He's big in real estate. And you have a real estate issue right now. And we want to know what the right thing to do. We want to have something which we call is fair and equitable. And we're not going for any body of law, but we just want to get his opinion because of his expertise or his experience in the field. There, that's a machlokes haposkim, if that's a problem or not. Because there, you're not going for an adjudication of a dispute. You're going for his opinion to know what's based on his experience. And that's really out of the realm of this year, but it's just leave it like that. It's a major machlokes haposkim. There's a Sman and Mitchas Pitim. There's many who weigh in on the shayla. All right. Can two parties agree? Our adversaries. We want. Each one feels why they are better off in court, and we would like to agree to go to court. Can we together agree that we're not taking this to Beis and take this to court? And the answer is no. That's also an issa. It's not waivable. You can't agree not to keep Shabbos this week, and you can't agree to eat chaza, so you can't agree to go to court either. It's an issa like any other issa, so it's not waivable. There is a certain type of waivable that means normally, in what you're going to learn, in order to get a heta to go to Arkaos, you need to have a certain hazmana process. Could be you could waive that process to a certain degree, which we'll discuss hopefully if we have time. But normally you cannot agree to go to court. So now the question is, what do we do with our contracts, which virtually every contract designates a body of law. It's going to be dealt with the state of Delaware because they're very easy on certain corporation laws, or it's going to be by the state of New York, the state of Florida. Are you allowed to insert such language into your agreements, into your contracts, if basically you're accepting a body of law which is secular, which is against halacha? So are you allowed to do that or not? So there's a Tshuvas Harash, and the Tshuvas Harash holds that really you're not allowed to do that. Really, that itself, you're accepting to go to court, which would also be a problem. But the Rosh says that since we're talking about Yidden, we zicha don't mean it. When we designate a body of law, that's only our fallback position. That means we intend to go to Beis and we hope to go to Beis. But what if one side is not cooperating? What if one side is playing games and we get a heta to go to court? Which body of law should then govern our agreement? That's what you wrote. It's a state of Florida. But it doesn't mean that we're lechatchila going to court. No, that's not.
Doesn't the whole fact, the whole operating agreement is listing laws and mahalchim on how to deal with it in the secular court? Isn't that clear? Like it's showing that like we do mean that we're going to go.
I don't know your operating agreements. I've written countless operating agreements. Any term you want to write, that's. And any term you would like to write, you could write any term you like. That's not an issa. You're allowed to write terms in your agreement. The problem is just that dispute resolution clause or the governing law clause, which it says what to do. That's really the problem. And that the Rosh says that it only means that if we need to go to court, we want to know which body of law to apply. So we're saying it's Florida, we're saying it's New York, we're saying it's Delaware, but it doesn't mean we're going to go there lechatchila. And if you're dealing with parties who really lechatchila are designating that body of law, then you'll have an issa kois just right then and there. Signing such an agreement could be in itself an infraction of the halacha, because then you're accepting a body of law which is alien to halacha.
But listing laws or
we don't list laws in the operating agreement. I'm not familiar.
You talk about how what will happen if this happens.
I'm allowed to write whatever I want. I could say what it is as long as I don't refer to their law and I'm not accepting their law. I could say if we want to have a buyout clause, and I could have we have capital calls. I could write anything I want in the contract. That's fine. Halacha recognizes that. Whatever you agree on usually works, barring other issues of asmakta or ribis or whatever it is. But that works. That's not a problem. The problem is accepting a body of law. Accepting a form, that's going to be the problem.
Is the contract valid if you do sign it, and is this problematic issue?
It doesn't void the contract. It doesn't void the contract. The question then is, a major machlokes haposkim, how do you deal with that clause? If people violated it and they wrote that clause accepting a foreign body of law, that's challenging in halacha now, because that's a machlokes. It could be you must still mechuyev to go to Beis, and then Beis might have to apply secular law as your psak, because the parties agree to it, which is very challenging in halacha. But all right, we'll leave it at that.
Unlike Rivers, is there an issue for the attorneys to draft that kind of a contract?
Well, like I said, it's not a problem of the contract itself,
No,
because
the law.
we just mean it. But it would be a problem. Let's just talk about in general. We're going to get to it shortly about lawyers. And now, wait, I want to get it in order. We'll get to it. We'll deal with the lawyers, that the lawyers actually have an issue as well. Ribbis even, you're right, Ribbis is on the lawyer as well. Okay. Now, I want to show you the Chomer Issa. This Issa is really, it's not, we talk about Zayod Avodah Zarah, but the Mechaber's language, I don't know if the Olam got up to the Mechaber, but the Mechaber's language, how he refers to somebody who goes to court, is Chol Habo leading b'fneim, Hareze Rosha. So, anyone know how many times the Mechaber in full Chelkei Shulchan Aruch ever referred to someone as a Rosha? Okay, and but he doesn't stop there. He was not happy with that. Hareze Rosha ukilu chireif v'gideif v'heirim yad b'toyres Moshe Rabbeinu alav shalom. Such language is not found anywhere in Shulchan Aruch. So Bais says the Mechaber views this as like the most chometika issa, and like I said, it's an abazar d'avodah zarah. Somebody who goes to court is possible to be a shliach tzibah. He's possible to be a shliach tzibah even if what he won in court is kedin. Means even if their law actually is the same as halacha, he didn't take an extra penny, or better yet, he even lost in court. So he didn't get anything out of the court. Nevertheless, he is possible to be a shliach tzibah. He cannot be a shliach tzibah. Not only that, the Kesef Kochim says he's possible to be part of a minyan. You can't count him for a minyan. And I know it might be a little more challenging. You go to out-of-town communities, you have smaller minyanim, so you can't count him for a minyan.
Is this both people in court?
Sorry?
Is this both people who are in court?
Whoever went to court is also. We're going to talk about the nitva, the one who was pulled to court, but the plaintiff in court, the one who initiated, who went to court, and this is halacha l'maaseh, and we had to use it very often in our Dinei Torah because of the timing. We have to make it. Sometimes we have to make our own minyanim, a mincha, a ma'ariv. I mean, we've had a ma'ariv in Bezdin at 3 a.m. We sometimes make our own minyanim, and it's not that difficult if you realize, because you have 3 dayanim, one safed dayan that's already 4. Usually there's someone taking shimush. We're right now 5. You have 2 toyanim. You're already up to 7. So you have a few balei din. You have a minyan just in the room, right? One time we had a case where we actually had exactly 10, and one of the parties, which was part of the din Torah, actually took the other party first to court.
So you didn't have a minyan?
So we didn't have a minyan. We didn't have a minyan. So we ended up, and everyone wanted to know, why aren't we davening here? And I said, no, we're going to have to go to a minyan. And it was a little sad because one of the balei din was an invalid, and he couldn't travel. But we couldn't make a minyan here because we didn't have a minyan. We did not have a minyan.
You should leave a minyan if they're counting someone also.
No. Okay. Wait a minute. Oh, there's only 10 and he's one of them?
10, yeah, and
So you don't have a minyan. I don't know if you want to dive in biyachidus. You can dive in biyachidus. You don't have a minyan. No, you're not accounted for a minyan. What?
No, Chazar, so shots for you, it's all minyan.
Oh, and economy, if you have all those issues, but you can't be Mazar for the minyan. And so we had that story. We've had that story, unfortunately, more than once. He loses his cheskes kashrus. So now, we had such a story, is that was a party who went to court, and he happened to be a mashgiach in a chasana hall. Well, he's not kosher to be a mashgiach. He loses his cheskes kashrus. He's not kosher to be a seifa. He's not kosher to... He's not kosher anymore because he lost his cheskes kashrus. Oh, there's tshuva for everything. A guy does tshuva, Gezin died. But while he's in court and he's also the mashgiach, that doesn't work. And even afterwards, you have to know that he did tshuva. Otherwise, Mishabur says you can't have him a shlik tzibah unless he does tshuva. But it means until you know he does tshuva, you can't have him as a shlik tzibah. He's a chiv, he's a novel. I know it's going to be the job of the Rosh Khal to go over to him and explain to him that he's just not fit to be a. That's how it is. He has to establish the fact. Whatever it is, he'll have to establish the fact.
If it's a group of Jews, let's say, and some of the parts of the group, they decide to go to court, and he is in Is that also?
Well, sometimes you'll have a bunch, but that doesn't give a heter because some people go doesn't give you a heter to
No,
go.
He was the minority. He's not
Oh, so then that means he went alapoy, so he couldn't do anything. So he's not controlled. He's not controlled. But there are ways, even then, that he could. Okay, but it's not really for now. There are ways, depending on the case, that he might be able. We've had that already. That he could go to Bezan on his chelik, and they'll go on their chelik. Whatever. It's an issue. Oh, we're going to get to it. We'll get to it. Believe that we're going to get to it. Not only that, the Shulchan Aruch, the Ramah Paskins, that someone who goes to court is subject to a nida v'cherem. That means he's excommunicated. He gets a cherem. Basically, he's out of the folk. He's out of the Yiddish Kehillah. He can't be buried. He can't, whatever they do. I don't know if they throw him out of yeshivas. I don't know what they do in Florida. But he cannot be part of the Kehillah. He can't come to this Monday morning program. He's out of the Kehillah. He's gone. He's
part of his tshuva. It's part of his tshuva.
Right?
It's part of his tshuva.
He had to do tshuva. This is not the tshuva. Tshuva is... but,
He does the tshuva outside.
yeah. Not only that, let's take it to the next step, Rabbi Isai. Somebody who aids and abets someone to go to court is also an Issa. His Issa could be a Lifna Iva or Messiah Issa, but ila halacha, you're supposed to put that person, the Marik, said he's putting everybody who's aiding and abetting this Arkaos to also be in Chayrim. So he's also subject to Chayrim. So this is very scary for lawyers, because lawyers sometimes find in a position, they have a client representing that client in court against another Yid. That lawyer is supposed to be put into Chayrim. That lawyer is doing an Aveira. That lawyer is aiding and abetting an Avla. He cannot take such a case.
Even if they're not religious, the litigants.
Now, if they're not religious, it's going to be a big, big problem. If they're both not religious, so then it could be an Eitzah. You get out of Lifnei Eva because if you won't take the case, someone else probably would represent them. So now you're only up to Issa Messiah, which is really not Choshen Mishpat Shayla. It's Yeridea, but in Messiah there's a Dagum Ravava. It's Machlokes Ramosha, Dagum Ravava that wants to say that if you're talking about someone who's fry anyway, could be and in that case there's no Issa Messiah. But what happens if you have one who is it from? One party is from. So let's say your party is from. Your client is from, and he's there without a het to Bezdin. The fact that the other client, the other party, the adversary, is not from doesn't give a het. Doesn't give a het. You still need a het to go to our client. You need a het. On absence of a het, you cannot represent that client. You're not allowed to represent that client. Sorry?
Okay, maybe there's a process.
Well, we're going to discuss the process of how to get a het, but Deval, in absence of a het, you cannot represent that client. Let's take it to the next step. And then it's all the family members as well. We had a case not so long ago where there was a certain askin, for whatever reason, was aiding and abetting a situation. And he was subject, and he was put under a lot of pressure. He was going to be subject to go into a chayrim because of his avera that he was doing. He was helping out somebody because that other person was really relying on him to finance it or whatever it is. And he was aiding and abetting someone to go to court, and he's subject to a chayim. Somebody who goes to court and wins in court, so he thinks, oh, he did it. No, he didn't do anything. He didn't. He has to start all over again. He has to go to Bezdin, and whatever he got in court, if he takes even a penny, is shalikadin and is gezel. He's taking, and Rabbeinu Bachai says, on that such a gezel, he's going to hard to him to do tshuva. He's never going to have a mechila l'olam because he's going to think it's rightfully his money. It's not rightfully his money at all. He had no right to that money. It came based on a goyish psak. That's not a yiddish psak.
Doesn't Chaver say that they don't? If he really went to a goyish court, they don't.
Ein Skokim. We'll get to it. But mitzad him, he has to find out what the halacha is. The halacha of Ein Skokim is when you lose. Right, the Ramah said it's when you lose in court. So, and we've had that. We've exercised that countless times already. The person goes to court, and sometimes goes to court on some issues. On the issues that he already went to court, and he lost, is ein niskaken. We will not take on that case. We'll only take on the case that they did not yet bring to court. But whatever he brought to court, so basically it's really not wise because in a practical situation, he's really giving the other party 2 bites of the apple. Because if he wins in court, he still didn't win, because he's still subject to the halacha. If he loses in court, he'll never be able to take it to Bezdin. So basically, you're just giving the other side another chance to win, unnecessarily. So he's supposed to really go to Bezdin.
What about all the cases based in never can adjudicate? Criminal cases?
No, for sure, criminal is not.
Zekin type cases?
Which one, the second one?
The Zekin type cases.
Zekin, why can't we pass on the Zekin? What do you mean?
Knossos?
Well, if we don't go to Knesset, then you can't go to court either on that. That's not a head to go to court because Bezdin doesn't do it. And the reason why Bezdin doesn't do it is because we need smuchim, like it says in Simon Aleph, goyim must for sure not smuchim. So that's not going to give you head. But you're right, criminal for sure is out of our area, and that has to go. That belongs in there, not here. What?
That's the first concussion. That doesn't mean you could go to another court. It means you just have to leave it as is.
Those hazekin that are loy shchiach, so therefore we do not have shluchusayo kavdinan. It's really not our topic. I don't want to get off track here, but it's not shluchusayo kavdinan. So we don't have the humana de malko, we'll call it. We don't have the authority to paskin. This is an important point. Is that when the Torah says Elam mishpan neshatasim lefneim, not only is it telling an issa, but let's talk in the positive. That the Rebbeinu Shalom just gave us the authority to adjudicate, to apply His law. That He just authorized us to do that. What we do not have authorization for, we cannot apply His law. If we're not smuchim, then we can't apply laws in certain cases. They'll have to figure it out amongst themselves. There are ways there are ways to deal with it, but that doesn't give you a right to go to court. Now we're going to discuss what to do with insurance. We'll just maybe what? What? Sorry. No, why do you ever have to go? First of all, there are Bati Din who will go with Din, and second of all, that doesn't give you a right to go to court. That still doesn't give you a right to go. If you could have people paskin, then you have to go to a paskin. The truth is, a Rashba talks about a case where they're in a place that doesn't have a bezin. What do you do then? And the truth is, Rashba said, still, just get together if you can. Any 3 yidden to be, it's better than going to court. Because if you can get someone to adjudicate, try their best, whatever they can, to apply the halacha. Otherwise, going to court, for sure you're going to not get the halacha. You're not getting the halacha, you're not getting the right body of law, you're not getting the right form.
Are you going to get to everything you want to get to with the question?
I didn't get, I'm like,
so maybe we should just get to it.
Okay.
Maybe we should save the question so you can get to what he gets to.
Okay, we'll try. Okay, I enjoy the question. I don't mind, but if you're right, we're running out of time. You know what? Let me see how far we get, and then if there's more time, we'll take questions. Okay, fine. Now, what do you do if the other party is a garva alma? He's not cooperating. He's not going to Bezdin. He's either a gangster or a trickster, whatever it is. He's really not playing along. And what do you do then? But let's say you're going to try to bring him to court, but you're not allowed to bring him to court. So what's the eitzah? So the eitzah is you send him 3 azmanas from Bezdin, and when he doesn't cooperate and he doesn't properly respond to Bezdin, at that point Bezdin will give you a heta akoyis. It requires a Bezdin to get a heter arkaos. That's a lashon machaba, and most poskim hold you need actually a Bezdin. One grand rabbi, the Gadol Ador, cannot give you a heter. Unbeknownst to people, they quote this rabbi always giving a heter. He can't give a heter even if he wanted to. You need a Bezdin according to lashon machaba. Derek Mishpat. On that matter, I can share with you a Gavaldik Chuvas Radvaz. Radvaz is a kadvain. Times of the Beis Yosef. So Radvaz had a case, interessante case. Watch this case. There's such a kind called Zablo. I don't know if the Ilum is familiar with it, called Zerber Le'echad, that we don't have, let's say, a Bezdin form, a regular established sitting Bezdin form. What we'll do is, I'll pick my dayan, you pick your dayan, and then the 2 dayanim pick a 3rd dayan. So we made a Bezdin, ad shift that we just made up ad hoc Bezdin. We just got a Bezdin together, we put them together. So in the times of Radvaz, there was a case where Reuven picked his dayan, Shimon picked his dayan. They have 2 dayanim, and they decided they don't need a 3rd. The 2 of them could pass in this case, and everyone agreed for such a form. That was great until one side decided not to listen to the psak. So then the Bezdin, these 2 people, gave a heta for the other side to go to court against his adversary because he's not listening to the psak. Zokter Advaz, the heter is not a heter because he only had 2. You had the 2 dayanim who were on the case, who both sides chose. They chose them to adjudicate. But they're not a bezdin. They don't have a power to send you to court. So their heter to go to court is not a heter. You need 3. As I thought, most all poskim say that you need 3. You need a bezdin. It's a lashon machaba. And in Lumdis, I don't want to go into it, but according to the Ksam Seif's London, for sure you need a bezdin to give a heta. It has to come from a bezdin. So but you get a heta usually if you send out 3 azmanas and the other party is not cooperating. Bezdin will give you a heta to go to court. So that's the way to go. Chulila, if you need to come on to it, that's the way to go. You go to bezdin, and bezdin will give you a heta to go to court. It could delay the court process a bit, but that's usually how it goes. It takes a few weeks to get his azmanas out, and then when he doesn't cooperate, they'll give you a heta to go.
If the time is very let's say there's a due date or something, there's a way of shortening the process.
You have to speak to the bezdin. Really, al pi halacha, you could send azmana Monday, Thursday, Monday. So you can really get 3 azmanas in 8 days.
No way of skipping, let's say.
No, you can't skip the process. When you talked about before about someone who's not from, there's a Dechuvis Minchas Yitzchak and Chelik Test, the end of Kuf Nun Hey. Others as well who want to suggest that if someone who's fry, you know really he's not coming to Bezdin anyway, so then it's enough if you send 1 hazmana and Bezdin will give a heti after 1 hazmana. We've had cases where we had countless times fry people at Bezdin. Not only that, we've had goyim come to Bezdin. And the halacha is that if you have a din Torah with a goy, you're mechuyev to go to Bezdin. The only reason, the Tashbats, and it's a medrash, and the only reason why we don't go to Bezdin with Goyim is because it's Kamara Nanzadi, 99.99% of the time, he's not coming to Bezdin, so therefore you don't need a Het HaKois, because it's automatic, like you have an Umdana, he's for sure not coming. But with a Fraya Yid, you never know, he might come, it's a far shot, but he might come, so if you have to send him at least 1 Azmana, and then Bezdin will usually give a Heta to go to court. You know how many people said never and they still came? I've had this so much. I'll never come. They write nasty emails to Bezdin. Mamish disgusting, like you would think that he's like 3rd graders, like mamish disgusting. And what happens? And they end up coming to Bezdin because the heat's on. And then they're coming to Bezdin because they know that that's the right thing to do. So the never doesn't mean anything. But the mitzvah, if he's a guy, then I understand that usually they're not coming. But you'll get a heta to go to court. There are some poskim, like the Nesivis and others, hold you can only get a heta to go to court when it's a chayv barer, when Bezdin's convinced that you're for sure right. That's a hard threshold to meet. However, that's not how we rule. Most poskim, the minik for sure is like that will give a heta even if it's not a chayv barer, and you can go to court, but you need a heta from Bezdin. Another halacha is very important. Rabbi said this is, maybe it's kedai to come to shir just to hear this halacha, is that even if you do get a heta to go, make sure you get it biksav. Why? Because later on it's going to come to haunt you. Later on you're going to come to Bezdin, whatever the case may be, the elder side will turn around and then take you to Bezdin after you start to go to court, and you're going to claim you had a heta from Bezdin. And you know what? Bezdin can't believe you. It's not allowed to believe you. You could say you have a heta from today to tomorrow, you're not Nemon, and it's as if you went to court Shaloi Kedin. You need to have proof. You have to have it in writing. It's also good to get it in writing because some Rabbanim may be quick to give a heta when it's really not so responsible, and when it comes to asking in writing, all of a sudden they're not willing to give it to you in writing. You know, that means the heta is not so convinced. They, a flipping cough while they're walking out of Mayrib, you ask them to Shaila, you can go to court, and then when it comes, okay, give me a heta. No, you can't go to court. No. So you need to have that heta in writing. We just have right now. We're in the Din Torah right now. The guy said, I have a heta to go to Bezdin. Show it to me in writing. You don't have it in writing? He didn't? Okay, so. Sorry? Adam would help. Do you have Adam on this? What? You can if you can get Adam on it, that will be fine. Without Adam, it's going to be a problem. Sorry?
Bezdin has Asmanas on fire.
For sure, Bezdin keeps Asmanas on.
So why is that never?
No, we're talking about people sometimes get Heterim. They get Heterim from Rabbanim without Asmanas. They get Heterim even from a Bezdin, but even you have Asmanas, but they don't have the Ksav Heta from Bezdin. And then Bezdin is not interested in whatever reason to give a heta. There was a misunderstanding. We will say it in nice ways. The bottom line is, if you don't get a heta b'ksav, you're not nem, and it won't work. Okay, someone asked before, what happens if you are called to court? Someone took Chulila, summoned you to court. Do you have a right to play along. Do you have a right to go to court? Let's say you feel it's better to go to court. We have this, especially when in matrimonial issues. For some reason, the lawyers convince the parties that they're better off in court. Now, it's funny, because of all the types of law, anyone who's familiar, that's the worst place for matrimonial issues, because there you sort of can predict at the outset what the judge is going to rule. There are no surprises there. There are certain standards. And the only ones who make money there are the lawyers themselves. No wonder why they're convincing you to go to court. They're the ones who make hundreds of thousands of dollars on this, schlepped out Agnes Navish. And basically at the get-go, I could tell you exactly, basically, because here's what the court's going to rule, and we could just cut a deal right now and save everyone time and money. But for some reason they go there, and each lawyer convinces his party they're better off in court. So one will start in court, and the other side will say, should I go to bed? No, lawyers don't go to bed and go to court. It's much better for you to go in court. And that's how it goes. So do you have a right to go to court if you were summoned to court? And the answer is yes. It's the Chuvas Knesset Cheskun Siman Tzadi Zayin. He holds that the Issa is the one who calls you to court. But for you being the defendant, you have a right to go and continue and go to court. That you have a right to do. However, it is Kedai Bais nevertheless to send the Tavei Hazmana. And I'll explain why, for a number of reasons. First of all, that might wake him up and cause him to have Hira Tshuva and come to Bezin, which will save somebody from doing an Issa, save a Chilul Hashem. There will be a Gevaldik Schus if you could accomplish that. But there's another reason why you should send him Hazmana. The halacha is that if someone goes to court Shaloi Kedin, he is liable for all the legal fees that he causes the other party to spend Shaloi Kedin. We've ruled, in fact, right now we're in the middle of such a case. We've ruled this countless times. If Reuven takes Shimon to court, Shaloi Kedin, it catches up usually. HaKadosh Baruch Hu has the last word. Catches up usually. They end up finding their way in Bezdin. A year later, 5 years later, they'll find their way back in Bezdin, and then the other party now demands from him legal fees, and the legal fees are significant: $50,000, $100,000, $150,000, depending how long they were in court, and they could mun back those legal fees. One of the halachas is, in order to mun legal fees, to claim legal fees, you have to show that you didn't want to be in court. So you took me to court, Khulili. I didn't want to be in court. Look what you caused me. Look at the damage you caused me. All these legal fees, I want to be reimbursed. But if you go to court and you follow the summons like a tatala and you don't send Azmana, there's no objection, so then we could assume you also wanted to go to court. What type of hezek was there? Both of you are varyanim. Matzah minas mina. Both of you found each other, and if you both went to court. But how can you claim legal fees? So according to some Baiskim, you can't claim legal fees unless you send the party an objection on Azmana to show that you want to go to Bezin. So for that itself, it's kedai to say chach one Azmana, showing that I object and I really want to be in Bezdin. There's another reason why you should send Azmana, and that is most of the time when it comes to issues, they're usually counterclaims. Not just claims, but counterclaims. Knesset Chesed gives you a right to go to court to defend yourself. But if now you want to be on the opposition and counterclaim back, well, those counterclaims you ought to be in a Bezdin. Why are you here now in court? Because he took me to court for the other issue. But why are you taking this issue to court? On your issue, you should go to Bezdin. So for your counterclaims, you should get a heter to go to court. Send us money from Bezdin. He'll most likely not cooperate because he's in court. Hopefully you will cooperate. But if not, then the Bezdin will give you a heter to file your counterclaims in court. So for that itself, it's good.
How quick do they do that process?
Again, the Hazmana process usually takes, depending on the Bezdin, usually they give like a week between Hazmanas. So it's about 3-week process approximately till you get your heta. If the guy's already in court, they might speed it up. If there's urgent, you could tell them about it. They might, like I said, a Monday, Thursday type of a shtickle. So there are ways, but you have to tell the Bezdin and describe it. But don't worry. In court, you have 3 months, 3 years. You have plenty of time. I don't know, maybe the courts here in Florida are much quicker. I don't know, New York, you could sit, so you could get white here before you get your case day in court. That's how it is.
If they call you as a witness on the court, you can go?
Ooh, okay, we'll mention it. We'll discuss it. Are you allowed to be a witness in court? So if the one who's calling, if it's between two Jews,
To remove a
two Jews, and the person who, the plaintiff, went to court, shaloi kedin, you going and testifying, what are you doing? You're aiding and abetting somebody who's in court, shaloi kedin. So you're now allowed to do it. You'll be oiven issa misayeh l'dei oivre aver, it's a chuvis ramah. You'd be oiven issa misayeh, and if you are a key witness, and he knows that you won't come to court unless he gets a heta, then actually you're the linchpin here. So that then actually it's a deraisa of lifnei evil itzita mitchell, because without you he would not go to court. So then you're upgraded from an issa derabbanan misayeh to an issa deraisa lifnei evil. That's what it comes out from the Chuvas Ramah. However, one second. However, if you look in the Yam Shloima and the Chavetz Chaim, they seem to learn, which is, again, is not the simple reading of the Ramah, they seem to learn that testifying in court in and of itself is an Isar Kois. It's not just your Oiva Lifnei Eva on his Isra Kois. You are Oiva Isra Kois testifying that, because it's like you also, although it's not your dispute, you are not submitting your dispute, but you're part of the process of adjudicating in court. You're part of that secular court system process. So then you are even Isra Kois by testifying in court. So therefore, if you're ever called as a witness, obviously you should ask him for, show me your heta. He tells you, I got a heta from a Rav. You're not allowed to believe him. You got to get a heta. Show it to me in writing. Or if you subpoena, you have a choice. That's a halacha and some lamadal. You have a halacha.
This is only for two yidden.
With two yidden.
Does it help? Does it help when you're
Goyim, you don't have a problem. We're all talking about two yidden where he does not have a heta to go to court. So then you have that issa.
What about the nitva?
If you're for the nitva, you have no problem because the nitva is there kedin. The nitva is never there shaloi kedin. But if it's a nitva's counterclaim that he doesn't have a heta for, so then he's there shaloi kedin. But that. But it's used. What do you mean? That deposition is part of a testimony. It's transcribed and it's used for the court system. So that will be the same problem. All right, let's.
What about jury? What if it's an insurance company that's deposing you, where the beneficiaries are not really? I mean, they're needed, but they're not really beneficiaries of the case. It's their insurance.
So again, if it's the one who's really, it's the insurance company who's part of the case, so then it's not between two yidden. It's the insurance company who's going to be shelling out at the end of the day. So that's really not so much between two yidden. When it happens, you should just consult a rav to make sure. But that l'chayr shouldn't be a problem. We're talking about when it's two yidden in the case. All right.
Yid's insurance is going to go up.
Yeah. Okay. That's why I said he should consult a rav and get the rav to go through and walk it through. Okay. I just want to end off with a hargasha, and then we'll develop it a drop. We have a few minutes, and that is HaKadosh Baruch Hu gave us the Torah. He gave us the Torah. That means he gave us the laws of what he felt would be best for mankind. The tikkun ha'olam, tikkun for each individual and tikkun for the world. Hashem created the world, and lahavdil, he gave us instructions, and that's the Torah of how to live in this world. If somebody goes to court, basically what he's doing at that moment is he's pushing aside that body of law, that set of law, and he's taking not what we call a das elikus, he's taking a das enushi. He's taking a man mind as brilliant of the minds that a man has, it doesn't come to HaKadosh Baruch Hu. So all the laws that could possibly be out there, all secular law, is at best human. That's all it is. It doesn't understand the dynamic of the world and what's behind the world and what's behind the scenes. It's not going to bring out tikkun ha'adam. It's not going to bring out tikkun ha'olam. And even in the laws that they pass in the same thing like halacha, but it's coming from two different perspectives. Hashem is coming from truth, from amitas hadava, what's best for the world, and they're coming what's fair and equitable, what they perceive as being right, but it's not from the same source. The Torah is a body of law that's beyond. It's godly. It's not human. And that's the issa. That's what it's based on. Elam mishpatim mishatasim lefneim. Going to Arkaos is a avodah zarah because basically what you're doing is you're bucking HaKadosh Baruch Hu, you're bucking Chulila the Torah, and you're taking on a body of secular law. So that's why it's avodah zarah. The Rambam says like this, a fascinating Rambam in the end of Hilchos Matnas Aniyim. The Rambam says like this. You need a Rambam to say this. Chayovim onu liyizah b'mitzvah tzedakah yoysim mikol mitzvah aseh. One has to be more careful with the mitzvah tzedakah than any other mitzvah aseh. Now we know that Eimach Hashem Scham mitzvah. We don't reckon one mitzvah against the other. We don't do that, right? But nevertheless, the Rambam says you have to be more careful with the mitzvah tzedakah than any other mitzvah. Why? Where's the Rambam coming from? Zok the Rambam, why? Because Shat Tzedakah Simin Lezer Avram. Tzedakah is not just a mitzvah. It's an identity. Tzedakah defines us. Tzedakah shows that we are Zera Avram. How do we know that? Because it says in the pasuk, Shenemar Zok the Rambam, Ki Yedativ HaKadosh Baruch Hu loved Avram. Why? Leman Sheyetzav Ezbonov Vezbeisay Akrov Lasois V'shomer Derech Hashem Lasois Tzedakah Umishpat. To do tzedakah mishpat. This was Avram's legacy to Klal Yisrael. Lasei tzedakah mishpat, and that earned him the love of the Rebbeinu Shalom. Do you know anyone else in the Torah that HaKadosh Baruch Hu was made that he loved? Anyone? Doesn't exist. Not in the Torah. Not. We talk about maybe Binyamin, Shloimeh, but not in the Torah. The only one is Avram. L'yedativ, I loved him. Why? Because he's going to lasei tzedakah mishpat. He's going to guide his children as Zer Avram. Zok the Rambam, this is the simon, it's a legacy of a Bnei Yisrael, of tzedakah. So besides the mitzvah, it's our identity. Comes along the Orech Mishpat, and the Orech Mishpat said, well, if the Rambam learned that out by tzedakah and applied to tzedakah, the same applies to Mishpat. What does the pasuk say? Lasais tzedakah u Mishpat. So the same thing, a person who goes to court is showing that he's not part of Zera Avram. Someone goes to Bezin, is that Simin Lezer Avram. Going to court is not Zera Avram. That's why a person has been more nizer in these areas than any other area. Because this defines us. This shows that we are Bnei Yisrael. We are Bnei Avram. I want to be Maysharim Rabbi Sai, a fascinating Drashis Chasam Sofer. You can look it up in Chelek Aleph, page Kuf Chof Aleph Amar Aleph. Somebody who goes to court, and this is going to tie in everything we discussed. Someone who goes to court, what he's in essence doing, he's being, I'm going to say over the Loshen, because it's a powerful Loshen. Moitzi atzmoi. He's removing himself, michlal bana matem l'Hashem l'keichem. He's removing himself from the category of being a bana matem l'Hashem l'keichem. He's not submitting himself under the umbrella of the Torah of the Rebbeinu Shalom. He's going to court. Umoicher atzmoi le'eved. He is selling himself as an eved lahasar shelo umma, to the sar of that umma. Every Goyish nation has an umma. Every Goyish nation has a sar. He is selling himself to that sar. Asher hu oimed lemishbar am imoy. If you go to a court in America, you just sold yourself as a slave to the Tsar of the Ummah of America. If you go to court in Switzerland, then it's the Tsar of Switzerland. Germany, it's Germany. You became an Eved, you were Moitzi Atzmim B'Chabonam Matem L'Shem L'Keichem. You removed yourself from the Torah, you removed yourself from the Am Hashem, you removed yourself from Zera Avram, you removed yourself from everything that's part of Yiddish society. That's why you talk about Avodah Zarah. The Ramah says it's right for Nidim Mecherim. Chulila, a person removes himself from being a Yid. It's a similar Zera Avram. We should be Zeicher Abaisai to always keep up that last tzedakah and mishpat, to walk in the street proud that we are Zera Avram, that we're keeping up his legacy. We should be Mekayim all the mitzvahs HaTorah, and we should always follow in the ways of Avram Avinu. We should keep the Torah. We should never be tested even to go to court, and with that schutz, we should never be taken to court. Shkoyik for listening.
Rav said about
what?
Not to use a court of strike to implement law.
So that also, if you want to compel arbitration, you could get ahead from Beis to compel arbitration.
But I thought that for things which are purely not litigation, you're not litigating in court, you're just implementing. You're allowed to go to court? For example, well, first of all, to carry out the din of the psak itself. How are you going to
Well, even in confirmation of a ward, usually that's a machlokes if you need a heter or bezin or not, because it might go under that's enul chachoy bara gadol mizeh, and that might be a little bit automatic like an arm of bezdin. But even then, the Bais say that you should get a heter from bezdin.
Bezdin itself, when you're there, they're going to give you a
They will most likely give you sometimes we give a psak and we don't give a heter to go to court because we're afraid that the psak is going to be abused in court. They're going to misuse it. We're not always, but most of the time we will give a heter to go to court too.
Signing arbitration, which means that that's binding.
It's binding. Everything is binding, but like everything, you still need a heter to go to court. So therefore, you should always. But then it'll be easy to get a heter, usually.
What about things that are not under the jurisdiction? Evictions.
Sorry?
Evictions or something. Something's not under the jurisdiction of the Beis.
Well, got the evictions you could get the person evicted through a process through Bezin too, but you're right, evictions are much easier in court, and in that case what they'll probably do is Bezin will allow you to start an eviction process in court, first have adjudication in Bezin. If you're right, they'll allow you to continue to evict in court. Hopefully he'll leave, the tenant will leave, and you only have to finish in court, and if not, at least you weld through the process through evictions, but if you're wrong, they'll make you pull it out of court. They just want to do it that you shouldn't lose the time. All right. Any other questions? I know they don't have questions, so now I'm here for questions.
The Rosh said that a judgment in court is invalid in Beis. Is that also true in a settlement? If you adjudicate in court, or you end up in a settlement?
So that's a good question, and that's really not for now 100%. It's not our sukkah, but basically is if you were forced into a settlement, then it could be under duress. I mean, if someone took you to court Lakewood, and the only way to satisfy that and put that away, put it aside, is by going into a settlement. So that you were forced, and if you make a maidah that you really don't intend to go into the settlement, you're just doing this to get out of court, then it will not be binding. But sometimes the settlement is done willingly, and if it's done willingly, so then that's nothing to do with the court system. It's a negotiated. So you have to know were you under duress to do it, were you forced to make that settlement or not.
You gotta enter Arkaos. If you're going to enter Arkaos, do you have to go back to Beis to see if the money you have is good?
So that's Nesivos holds yes. Not everyone agrees with that. Not everyone agrees with that.
Also, the Rav said that when it comes to matrimonial law, anyone can know ahead of time how the court is going to pass it.
Most of the time means they'll know about. There's a basic rule book of what mezainis are. The basic rule, because he has not too many surprises. Everyone thinks they're going to show the judge what the other spouse is crazy. But the judge knows that they're both crazy, so not a problem.
The question is Bezdin as predictable? Because that's what people think Bezdin is not predictable.
Bezdin is almost also, because it's basic rules, it's all the halachas of what to do with the boys and the girls and mezainis. It's you go to someone who is familiar with the process, who'll be able to show you this is your upside, this is your downside, this is your window where you're looking at. Ziv Rothschild from Lakewood, Allah Shalom, he was the one who used to do mamish. He used to mediate instead of to avoid them to going to even Bezin or court. He used to mediate and make divorce settlements. He used to do 2 a week, and basically because he would sit down the bar and say, "Look, either you could fight for 2 years, and waste hundreds of $1,000s thinking in the wind, but I'm telling you it's going to be the exact same thing. These are the windows. These are the parameters. You can give or take a little here, a little there, and let's work something out." And he used to do it because mamish used to do 100 a year. But Nabuchi was nothing.
That they don't settle based on halacha is that the equivalent of going to Arkaos.
The Rabbanut or the Beit HaMishpat?
Well, but they don't follow the
If they don't pass in halacha, then it's the same thing. But a lot of Rabbanut do pass in halacha. I'm saying you have to know.
No, not for the splitting of property.
It's like divorce?
Yeah?
Yeah, divorce. Yeah.
Okay, so then if they're not...
Threatening somebody with lawyers, like, I'm going to take you to court.
So a lawyer's letter is also going to be about if you threaten someone to go to court, is like, just like you're now allowed to pick up your hand to hit someone even before you hit it, is a Russia, right? So Reb Nissen Zatzal told me that if you send a lawyer's letter to go to court, if it's an emissary threat, and it's the same problem. But if it's a fake threat, or you put into the threat of the lawyer's letter that you don't say you're going to court, you're going to adjudicate this matter, or you're going to...
yourself according.
Exactly, right? Or you write in there, even you throw out an option, you're willing to go to Beis, but if not, you intend to pursue your rights in court, but you gave that option, that will be fine. It means you covered your bases.
And also briefly, what the Rav says, let's say if you wanna
Sorry?
buy some of them.
I want to sit down soon.
Okay, fine, no problem.
When
I'll get to
advise
my-
some non-from people to go to Beis Din. Some people are not aware about what's the process, how it should work. Nobody explains.
So you sit down with them, explain to them they have to go to Beis Din. What?
We have a case that we have someone to go to a Safra Diner. The Safra Diner said it should be discussed by the rabbis of the city, and that person got like, listen, the Beis Din is really a joke. So they feel like he felt like it wasn't really getting anywhere, and he wanted to go to.
Look, I don't know your specific case, but today we have established Bati Din. You can call them, and now with the world became a lot smaller with Zoom, we've done numerous cases over Zoom. You call a Beis Din, an established Beis Din, they'll set up a case, they'll do it over Zoom if need be, even if you're out of town, and they'll have a case over Zoom.
You're allowed to do over Zoom. Don't they have to go to Beis Din and Stok?
You're allowed to go over Zoom, I know. You're allowed to go over Zoom if the parties are masking. There's a halacha that I could want to be in front of you, that I want you to lie in my face rather than over a Zoom. I can insist on that.